Welcome back to this third part of contract law, acceptance. What we will be also looking at though, going forward within this session, is we will consider intention to create legal relations, and we will also, in the final segment, further consider certainty of terms. So, we were looking in the last segment at the exceptions in relation to the rule that acceptance must be communicated to the offeror. And the exception that we ended on, of course, was the postal rule. Now, if we pick up back on that, the postal rule starts with the case of Adams and Linsell, an 1818 case. And in Adams and Linsell, the defendant wrote to the plaintiff offering to sell wool and requested a reply in the course of post. Now, the defendant misdirected the letter, and this caused it to be delayed for a couple of days. On receiving the letter, the plaintiff replied immediately by posting a letter of acceptance. After the plaintiff's acceptance was posted, but before it arrived, the defendant sold the wool to a third party in the belief that the plaintiff was not interested. The court decided that a contract was concluded between the defendant and the plaintiff when the letter of acceptance was posted by the plaintiff. Now, the approach might appear to be a contradiction in terms of the idea of contracts being based on the meeting of the minds, but what it does in fact show is that you need to consider it from an objective standpoint rather than from a subjective standpoint. Now, consider the significance of Adams and Linsell, and it is this, that once a letter is posted, immediately upon posting, in the context of acceptance, you will have a binding agreement. Now, that is so because it operates as an exception to the acceptance rule that you must communicate acceptance. The reason I'm emphasizing this is that because there are times when the examiner, knowing full well that you are under pressure in the exam, will do something really sneaky, and he will throw in an offer in the context of the postal rule, and more often than not, the average law student will then start discussing the acceptance rules. So, a question, for example, like this. The examiner says to you that A offers his car for sale and he puts the sign on the windshield. So, what we have is a unilateral offer. And let's assume that the examiner that then tells you that A, B, and C have looked at the car. The examiner says A has stopped at the house to make an offer, B has written to A, but then the examiner rather cunningly says it was 6 p.m. C just saw the sign on the windscreen and rushed to put her acceptance in the post for the car. Average law student is going to pick it up and run along the wrong path by saying, oh, this is the acceptance rule. Remember that the fact that you're looking at a unilateral offer there for the sale of the car, it means that, because it is that you're looking at an advertisement, my apologies, because you're looking at an advertisement for the sale of the car, what you get is it's an invitation to treat. It means that A, B, and C are making offers. It means that when C pops her supposed acceptance in the post, all C is doing is making an offer for the car. And an offer is only good when it is communicated, meaning that it will only be of any value when A actually receives it. However, if A had told C directly that A was selling the car to C and C popped the acceptance in the post, then you're looking at the postal rule in the context of acceptance. Remember, the postal rule only applies in the context of acceptance. Please do not let the examiner lead you a merry dance. Don't allow him. Now, the rules even apply in cases where the letter of acceptance is delayed or lost in the post. And of course, we see the case well, there are certain cases certainly that go down this route or show that this is the case: household fire and carriage accident insurance and grant. But the letter at all times, even if it's lost or even if it is delayed, the letter must at all times have been correctly addressed and stamped. Because the idea of the postal rule, or one theory as it relates to the postal rule, is that the post office is acting as an agent of the offeror. So the minute you drop it in the post, it is deemed accepted. But it is only deemed accepted if it was correctly addressed. There is a little known case, Re London and Northern, which says that if it is not correctly addressed and stamped, then it is unlikely that it will be deemed appropriate acceptance. Question: can an offer be accepted by a person who has no knowledge that the offer exists? Well, again, we have to consider the old concept, the old principle of the consensus addendum. This situation can occur where, for example, someone performs an act or service. So they return an item of lost property to the owner, and then it is afterwards that they learn that there was a reward, in fact, being offered for the performance of that act. Now, in one sense, such a person has fulfilled the terms of the offer, and it could, of course, be argued that he is entitled to the claim for the reward because, as law students like to tell me, it's only fair. But the point, of course, is, and I will say this to you, and I'm certain you will more or less have heard it before, is that the law isn't necessarily about fairness, because fairness and justice have a somewhat subjective quality about them. Whereas if you look at certainty of the law, that is, in my view, ranking a little bit higher than the whole justice and fairness. Because looking at such a situation, you'll say, well, Jennifer, you were offering a reward if somebody returned your lost pair of glasses. But then the law is saying, well, the person who returned it didn't know about the offer, and so he should not get it. But it is that feeling of justice and fairness, as I say, that would certainly give rise to the argument that he should be so entitled. But in this type of case, there is no agreement or meeting of the minds. The acceptance is accidental, as the act or service is not given in exchange for the offerer's promise. Yet we see in Gibbons and Proctor, the court appeared to decide that ignorance of an offer did not preclude a person from claiming a reward where he gave information and then later learned of the existence of the offer. The case has been open to criticism, but there is, of course, another report of it which suggests that it was significant that the plaintiff did know of the reward by the time the information was passed via the plaintiff's agents to the appropriate person. Now, the Australian case of R.V. Clark is a more widely approved statement of the law. It concerned an offer of a reward for information leading to the arrest of certain murderers and a pardon to any accomplice given the information. Now, the claimant gave the required information but admitted that he had forgotten about the reward at the time that he supplied it, that is, when he was in custody himself, charged with the murders. The claimant's claim for the £1,000 reward was rejected by the High Court of Australia, and the case was treated as if he had never known of the reward. Now, one of the things that you have to also consider is, does motive have anything to do with there being acceptance? And by and large, it doesn't. If you know about the reward and you've given the information, it doesn't matter what your motives are. Case, of course, for that is Williams and Carradine. Now, the last point on acceptance that I would certainly raise is, what if you are seeking to terminate an acceptance by a quicker method? Now, this is where, for example, the postal rule will always have been used by the examiner. He will have, for example, A making is offered to C directly, and C popping is acceptance in the post. But C thinks after a while, oh, I don't think I want the car anymore, picks up the phone to call A and say to A, You're going to get a letter from me, but I wish for you to ignore it. Question: can the offeree withdraw his acceptance after it has been posted by a later, quicker communication, which then reaches the offeror before the posted acceptance? Well, there is no clear authority in English law. There is a Scottish case of Dunmore and Alexander, 1830, which appears to suggest, and I stress this suggest because this is one of the most misused cases at time, it suggests that such a revocation is permitted. Case, as I say, Countess of Dunmore and Alexander, 1830, has been cited for the proposition, but interestingly enough, in the case itself, it was obiter, as both the offer and the purported termination arrived at the same time in that case. But it is an unclear decision. The fact is that taking a strict application of the postal rule, it would not permit such a withdrawal. And indeed, there are two cases. There's a New Zealand case and a South African case which have both looked at this particular area, and they have pretty much stood on the principle of the general common law rule. Cases, if you wish to look at them, of interest, of course, New Zealand is the Wenkheim and Arndt, or Venkheim and Arndt, and the South African case of A to Z Bazaars and Ministry of Agriculture. However, such an approach is regarded as inflexible. If you're doing an essay, certainly say that and make the suggestion that the position that is often referred to in Countess of Dunsmore might be the better approach. That being said, if it's a problem question, certainly I would suggest you go back to the strict common law English position. So, once you have your offer and your acceptance, then the next thing you need, of course, is an intention to create legal relations. And certainly, you need to ensure that the terms are certain, and consideration, which is for another lecture. But what we're going to do now is we are going to pause and we are going to consider immediately after the break intention to create legal relations, followed by certainty of terms, and that would then conclude the session.